Jeff Lewis is with us tonight. He's a constitutional scholar and attorney. Jeff, ethical guidelines. They say judges should avoid even the appearance of impropriety. Does going to a prayer meeting count?
Not really. In these kinds of matters, context is king, and simply going to a prayer meeting alone without other factors is not likely a problem. Now, if the justices are engaged in a prayer meeting at the Supreme Court with members of a party that has a lobbying brief in front of them in a time proximate to the court deciding an issue related to that party, you bet it's a big problem. So context is king here.
Okay, and so anyone is welcome to file a brief with the court. If it's not their specific case, that's still an issue. Like, you know, if I'm part of a group, I can file an amicus brief.
Absolutely, and my office has filed amicus briefs, but I don't have prayer meetings or breakfast meetings with the Supreme Court justices in a time proximate to my filings or when the court is about to make a big decision in a case that I have briefed in one of my briefs.
Okay, so we know every president, and they're very public about it, they hold prayer breakfasts in the White House with religious groups and advocates. Congress has Bible study groups where pastors drop by, which are advocating for certain positions and laws. So the entire government, it's written into the Constitution, is supposed to heed this separation of church and state. How would the court be any different?
Well, keep in mind, our First Amendment prohibits the government from establishing a religion or preventing people from exercising the religion freely. And sometimes those two parts of the same amendment are in conflict. President Biden had a reverend give an opening prayer at his inauguration. Our history of government functions and ceremonies have religious leaders and prayers. So the mere fact that our government has religious activities is not in and of themselves a violation of the First Amendment. It's only when the context suggests that our government officials are establishing or preventing the free exercise of religion that it's really a problem.
Okay, so take me to the core of it then, if you would, Jeff, because here in Washington, you're in LA, I'm in Washington, everybody works for a nonprofit. Everybody works in Congress or for an advocacy group. Does this mean that Supreme Court justices can't have friends who espouse any position? Or, you know, Clarence Thomas, his spouse has a position. Like, where is the line?
Yeah, again, it's all about context. There's nothing wrong with justices having personal lives. We want justices on the Supreme Court who engage in everyday activities and who represent the kind of activities that we all engage in. The bottom line, though, is if a litigant wants to get a fair shake in court, they want to know that their judge or justices aren't predisposed to hear their case or decide the case before arguments have even started. So who are the prayer meetings with? Where were the prayer meetings happening? And is there an issue before the Supreme Court relating to prayer? The answers to those questions suggest whether or not these justices should or should not have recused themselves.
Okay, so we know Chief Justice John Roberts, he is very aware of this and jealously guards it, trust in the court, but it's falling fast. Here's been a hobby horse of mine on this show for 5 years. The court used to be more removed from the public. They always had the highest approval ratings. You didn't hear the cases argued. You didn't know their personalities. You didn't even know what their voices sounded like. To keep the Supreme Court from becoming Congress, all the show horses on, you know, C-SPAN and on cable news, shouldn't they be less public maybe?
Well, that's a great question. I don't know if the lowered trust in the courts has more to do with their public participation in public events, or if it has more to do with the eradication or lowering of norms associated with the judges. Keep in mind, we haven't had in recent history a big black fence erected around the Supreme Court for their security. We haven't had judicial opinions leaked. We haven't had 50 years of precedent discarded. This eradication of norms is really what is the key to the lowered trust in our courts, rather than the justices engaging in public life.
So step one of re-engaging the public to regain their trust. What is that step?
Yeah. It all comes down to precedent. Finding a way to rule on cases as they come before them and make it respectful of precedent. So it doesn't seem that decisions of the Supreme Court change based on who's making those decisions, but that we have a uniform set of laws that apply equally to everybody.
Constitutional attorney Jeff Lewis. Interesting perspective tonight. We appreciate it, Jeff.